At its core, a contract is a private reallocation of risk between two parties. We make legally binding agreements to lock in prices, secure supply chains, and create certainty in an inherently uncertain world. But no agreement can account for every variable. When a supervening, entirely unforeseeable disaster completely destroys the ability to perform, the legal system has to decide who pays for the wreckage. Contract law is governed by a fundamental tension. On one side, global commerce relies on strict, absolute certainty. Promises must be kept. On the other side, equity demands a mechanism to relieve parties from unbargained-for catastrophic hardship that neither side could have predicted. To understand this boundary, we must map the three common law exceptions to strict liability: impossibility, commercial impracticability, and frustration of purpose, and examine the Uniform Commercial Code's mechanical default rules used to assign risk of loss. When disaster strikes, the legal system forces a binary outcome. Either the contract functions as a rigid cage, forcing one party to absorb the financial blow entirely, or the contract shatters, legally discharging both parties from their obligations. The traditional baseline for contract enforcement is absolute liability, perfectly illustrated by the 1647 case of Paradine v. Jane. A tenant leased a farm, but during the English Civil War, an invading alien army occupied the land for 3 years, expelling the tenant and preventing him from taking any profits. When the landlord sued for unpaid rent, the court established a strict rule. If a party creates a duty upon themselves by private contract, they are bound to fulfill it despite inevitable necessity. The reasoning was simple. The tenant could have explicitly drafted protections against military invasion into the agreement. Because he did not, he held the risk. That absolute rule dominated for over 2 centuries until the 1863 case of Taylor v. Caldwell carved out the doctrine of objective impossibility. In this case, a specific music hall was contracted for a concert series, but it was completely destroyed by an accidental fire before the first performance. The court recognized an implied condition in the contract. If performance fundamentally depends on the continued existence of a specific person or thing, the destruction of that subject matter, without the fault of either party, makes performance physically impossible and legally excuses both sides. Impossibility is not always permanent. In 1942, cowboy actor Gene Autry was drafted into the United States Army during World War II, creating a temporary impossibility that suspended his multi-year movie contract. After the war, the studio relied on a military service clause in the contract, arguing that Autry was required to finish his unfilmed movies under the original, pre-war financial terms. The California Supreme Court disagreed, establishing the modern metric for temporary impossibility. A temporary delay operates as a permanent discharge of duty if performing those delayed obligations would impose a substantially greater economic and physical burden on the promisor than originally contemplated. To successfully trigger the doctrine of impossibility, the barrier cannot simply be inconvenient. It requires the literal physical destruction of the subject matter, supervening illegality, or an unconscionable, oppressive shift in the burden of performance. Eventually, courts recognized that catastrophic events often destroy the financial viability of a contract without physically destroying the goods themselves. This led to the doctrine of commercial impracticability. The boundary of this doctrine was tested in the 1966 case of Transatlantic Financing Corporation versus United States. A shipping operator agreed to transport wheat from Texas to Iran, but while the ship was in transit, international warfare caused the unexpected closing of the Suez Canal. The physical blockade forced the ship to divert around the Cape of Good Hope, adding roughly 3,000 miles to the journey. When analyzing claims of commercial impracticability, courts apply a 3-part test. First, an unexpected contingency must have occurred. Second, the risk of that occurrence must not have been allocated by the agreement or by custom. Third, the contingency must render performance commercially impracticability. The shipping operator met the first 2 criteria, but the financial data undermined the third. The diversion added about $43,000 in extra expenses on top of a $300,000 contract price. After delivering the wheat, the carrier sued for quantum meruit to recover the difference. The court rejected the claim. The wheat cargo was entirely safe on the southern route, and the ship and crew were fully fit for the extended voyage. The court ruled that a mere increase in cost or distance does not equate to legal impracticability. Sophisticated commercial entities are legally presumed to foresee and absorb standard financial risks, including global market fluctuations and logistical delays. The courts will not use the doctrine of impracticality as a retroactive insurance policy for a bad profit margin. The final common law excuse is frustration of purpose. This applies when performance remains physically possible and costs have not escalated, but a supervening event utterly destroys the underlying mutual motivation for entering the contract. The doctrine originates from the 1903 English case of Krell v. Henry. A renter paid a steep premium to hire a flat on Pall Mall for 2 specific days, explicitly chosen to view the royal coronation procession. Before the dates arrived, King Edward VII fell seriously ill, and the coronation parade was cancelled. The court held that viewing the coronation was the mutually understood absolute foundation of the contract. Because that shared premise vanished, the cancellation completely frustrated the object of the venture, excusing the renter from paying the balance. Decades later, the limits of this doctrine were tested in the 1981 case of Downing v. Stiles. A buyer purchased a restaurant, but stopped making payments on her promissory note when an adjacent bar closed down, significantly reducing her customer foot traffic. The buyer argued commercial frustration, but the Wyoming Supreme Court applied a strict 6-factor test and rejected the defense. The principal purpose of the contract was to run a restaurant, a task that remained entirely possible even without the neighboring bar's patrons. For this defense to succeed, the frustration of purpose must be total or nearly total. A drop in revenue or the closure of a neighboring business is an ordinary commercial risk, not the destruction of a shared contractual foundation. When a contract for the sale of goods is silent regarding liability and a disaster does not meet the high threshold for a common law excuse, the Uniform Commercial Code steps in. The UCC imposes rigid default rules to determine exactly who bears the financial loss. Instead of evaluating subjective hardship, the UCC allocates risk based strictly on the physical control of the goods and standard shipping terminology, mapping the transaction across 3 distinct parties: the seller, the independent carrier, and the buyer. Under FOB, or free on board terms, the stated location determines liability. In an FOB shipment contract, the risk of loss passes to the buyer the moment the seller properly delivers the goods to the carrier. In an FOB destination contract, the risk remains with the seller until the goods safely reach the buyer's location. These statutory provisions, UCC Sections 2-319 and 2-320, codify standard shipping terms, further defining designations like FAS, meaning free alongside ship, and CIF, which bundles the cost, insurance, and freight into the quoted price. If goods are held by a commercial warehouse, known as a bailee, and are meant to be sold without being physically moved, the risk of loss transfers from the seller to the buyer exactly when the buyer receives the official document of title. For direct local deliveries not involving carriers or warehouses, the rule depends on the seller's status. If the seller is a merchant, the risk of loss passes to the buyer only upon actual physical receipt of the goods. For non-merchants, risk passes the moment the goods are merely tendered for delivery. The UCC's mechanical framework ignores the intent or misfortune of the parties. By tying financial liability strictly to physical dominion and standard commercial phrasing, the code guarantees that supply chains keep moving even when cargo is destroyed. The baseline paradigm of contract law is deeply pragmatic. Losses are left to rest exactly where they fall. The courts refuse to rewrite bad bargains or rescue commercial entities from ordinary market volatility. Legal excuse is an incredibly narrow escape hatch. It is reserved strictly for the absolute physical destruction of the subject matter, an extreme and unforeseeable temporary hardship, or the total collapse of the mutual premise upon which the contract was built. If a party successfully proves impossibility, impracticability, or frustration of purpose, the contract is legally discharged. It becomes a legal nullity, releasing both sides from their future obligations. However, to prevent unjust enrichment from work already completed, courts apply the equitable remedy of quantum meruit and restitution. Following precedents like Carroll v. Bowersock, a court will only order compensation for the value of permanent, tangible benefits conferred onto the property before the disaster struck. Reliance expenditures and preparatory work are not recoverable. Ultimately, modern contract law is a continuous balancing act. It enforces the rigid predictability required to operate global markets, while carefully preserving a narrow, equitable failsafe for truly catastrophic, unbargained-for acts of fate.